Swayam Prabha. Digital India. Educated India.
Hello friends, welcome to 14th lecture of our course on law of copyright, patent, trademark and other IP. In this 14th lecture, which will be the last lecture on patent law, we will be talking about compulsory license and revocation of patent. After this lecture, we will be devoting 4 sessions on trademark law, and the last 2 sessions will be on other IP, which includes some discussion on protection of plant varieties in Farmers' Rights Act. We'll be discussing a bit of geographical indications law, and a part of the lecture will be based on protection of industrial designs. So let's talk about 2 important topics in patent law. One is compulsory license and the other is revocation of patents. But before we talk about compulsory license, first of all, let us understand what do we mean by transfer of patent rights, which we have in section 70. Transfer of patent rights can be done by 2 methods. One is assignment, the other is license. As we discussed in copyright law also, transfer of ownership would mean assignment. Assignment means creation of interest in favor of transferee. So it is a situation where you are transferring almost the ownership of the patent, whereas in case of license, the licensee is authorized to exercise certain patent rights. So that's the fundamental difference between assignment and license. Same as copyright law, here also both these documents must be executed in writing, must be signed by both the parties, and the agreement of assignment or license must mention all the terms and conditions, including rights and responsibilities of the parties. Section 69 subsection 1 talks about registration of title, registration of interest. In case of assignment, the title will be registered. In case of license, the interests acquired by license will be registered, and assignee is registered as proprietor, whereas in case of license, the interest will be specified in the register. So therefore, the fundamental ways by which you transfer your patent rights are assignment and license, and the fundamental difference between these two is in assignment there is creation of interest in favor of transferee, whereas in case of license it is only authorization to exercise certain rights. Now coming to the point of compulsory license, we are talking about a license different from voluntary license. This is not an authorization given by the owner of patent rights voluntarily. Compulsory license means a license granted by the government to a third party without the permission of patent holder. So this is not something which is happening out of volition. The patent holder is not parting with his rights out of volition. He is not authorizing you to do it out of his consent, but the government is doing it. And let me tell you, this is one of the very important public interest provisions in Patent Act 1970. Why do we grant compulsory license? What are the objectives of granting compulsory license? First of all, let us see that. If you see, the first point here is, if we first of all see the object of grant of patent, there are 2 points which are clearly mentioned here. I have mentioned it in the beginning of my session on patent law, where I said one of the objectives of patent law is to encourage further creation. IP laws must not only promote creation, IP laws must also encourage working of the inventions. So therefore, there are 2 things mentioned here. Patent encourages creation and it promotes commercial working of these creations. Then there is an important provision in section 83 which says that patent must not be made available at an unreasonable price. It must be made available to the consumers at a reasonable price. Patent law must facilitate technology transfer, dissemination of technology nationally, internationally. It must not impede protection of public health. It must not be against public interest. And it must not impede national industrial progress. I can compare the whole of it with Articles 7 and 8 of TRIPS agreement, if you recall. Patent protection must encourage creation. Patent protection must also promote dissemination of knowledge, commercial working of the invention. Technology transfer must be done on mutually agreed terms. It should not be tilted in favor of creators of invention. It must also take into account the interest of users of patent. It must not impede protection of public health. Patent law must not be against public interest. And patent law must not impede national industrial progress. Any exercise of patent rights which is in violation of the objectives which I just mentioned, which are listed in section 83. Any exercise of patent rights in violation of objectives of section 83 give me a ground for issuance of compulsory license. If the owner of patent rights is abusing his rights or is non-using his rights, abuse, non-use, these are the situations where we can say that objectives mentioned in section 83 are violated. And that gives me a basis to issue compulsory license. As I said, compulsory license is a license which is not granted out of volition. It is granted by the government to a third party, and it is granted in public interest for the purposes which are mentioned in section 83. This is the broad understanding of the concept of compulsory license. Let's go in detail of this point. You can see the procedure is mentioned on this chart, how to go about claiming compulsory license. It all starts after grant of patent, you can see. Once patent is granted and 3 years have elapsed since the grant, an application for compulsory license may be filed by anyone after 3 years from the grant of patents. Let me tell you once again that date of grant of patent is the date of filing of your application. So, when you file your application in the year 2015, 1st January 2015, and eventually the patent process was completed in 2018, the date of grant shall not be 2018, shall be 2015 only. So, date of grant shall be the date of filing of application. After 3 years of date of grant, an application for compulsory license may be filed. The first thing which the controller has to see as to, is there a prima facie case? Now, this has to be seen in the opinion of controller. In the opinion of controller, is there a prima facie case? Of course, he has to make an opinion on the basis of submissions made by the applicant of compulsory license, because the applicant has to be any interested person. And if you remember, I said it is defined in your Patent Act section 21T. In the application, the interested person has to explain nature of interest. How is he an interested person? He has to give facts in support of his claim to get compulsory license. He has to also explain acceptable conditions, conditions which are acceptable to him, on what terms and conditions he is willing to accept the compulsory license, because he may not be willing to accept the compulsory license after paying remuneration which is very high and beyond his capacity. So therefore, interested person who is going to file an application for compulsory license will have to explain nature of his interest, facts in support and acceptable conditions. And on the basis of these, controller has to make an opinion whether there exists a prima facie case for issuance of compulsory license or not. If the controller is of the opinion that there is no prima facie case, then in that case, the controller will inform the applicant that, see, your application is devoid of merit. You failed to establish the prima facie case, and therefore, after giving hearing, the compulsory license will be refused. On the other hand, if the controller is of the opinion that there exists a prima facie case on the basis of material which the interested person has supplied, that is, nature of interest, facts and support, acceptable conditions. On the basis of these, if the controller comes to the opinion that there exists a prima facie case, this appears to be a good case for issuance of compulsory license, then in that case, controller will notify the patent holder that, look, somebody has made an application and is giving grounds for issuance of compulsory license. Now, this notification to patent holder has to come from applicant also. Applicant will provide copy of his application to the patent holder. This application, which according to controller has some merit, will be published in the Journal of Patent Office. After publication, within 2 months, if nobody is raising any opposition to the claim of compulsory license, listen to me carefully, there is a prima facie case, the patent holder is notified, the application which according to controller has some merit is published in the official Journal of Indian Patent Office. Now, from the date of publication, within 2 months, nobody is raising any objection. And this is a situation where an application is unopposed. An unopposed application for compulsory license shall be granted, On the other hand, there is some opposition within 2 months. Who can raise an opposition? Patent holder can raise an opposition. He may oppose that the grounds mentioned by the applicant for issuance of compulsory license do not exist. Or if the holder is not willing to raise opposition, he is not opposing grant of compulsory license, in that case some other person may also oppose the application. Who can be that other person? Some other person will include the licensee of patent holder who may be exercising rights. And in case a compulsory license is issued, that licensee will have to lose his license rights or will have some competitor. So therefore, in case after publication within 2 months somebody is opposing, and when you are opposing, when somebody is opposing, he has to give grounds for opposition, he has to give evidences in support of his opposition, or if he thinks that the conditions mentioned by the applicant are not acceptable, then he has to give his acceptable conditions. So, if he has no problem with the grounds and other things, he only has a problem with the conditions which are mentioned by interested person in his application, then he will present his conditions. So, these are the things which the person opposing will have to write as to what are the grounds on which he is opposing the claim for compulsory license, what are the evidences in support of his grounds, and if he has problems with the terms and conditions, what terms and conditions are acceptable to him, he has to explain these points. Now, on the basis of both the documents, one which is given by interested person and one which is given by the person who is opposing, opposition proceeding will be conducted, and finally a decision will be taken whether it is a fit case for grant of compulsory license or whether compulsory license should be refused. So, this is the procedure to obtain compulsory license. As I said, it starts after grant of patent. Once patent is granted, within 3 years, any interested person can file an application for compulsory license. Controller has to decide whether there exists a prima facie case. If there is no prima facie case, the case is over. The compulsory license will be refused. In case there is a prima facie case, patent holder shall be notified, application shall be published, oppositions will be invited in 2 months. On the basis of opposition proceedings shall be conducted, and a final decision as regards granting or refusing to grant compulsory license shall be taken. So, compulsory license is something which government grants without the consent of the patent holder, and it is done in public interest, and it is done according to the procedure which I just mentioned. Broadly, I said compulsory license will be issued in case the objectives of section 83 of Patent Act are violated. Now, coming to the conditions, the grounds on which compulsory license can be issued. We have 3 grounds for issuance of compulsory license. The first ground is when the patent holder is not fulfilling the reasonable requirements of the public. Reasonable requirements of the public about the patented material is not fulfilled. Second, when the patented product is not available at a reasonably affordable price. And third, when the patent holder is not working his invention on commercial scale in India. So, these are the 3 grounds on which compulsory license can be issued. Let us understand these 3 grounds in a bit detail. There are various situations when we can say that first ground, that is reasonable requirements have not been met, is existing. So, when can we say that reasonable requirements are not met? Let us see that first of all. I said there are 3 grounds: non-fulfillment of reasonable requirements of public, second, non-availability of the patented product at reasonably affordable price, and third, non-working of patent on commercial scale in India. Let's come to the first ground. If the patent holder does not meet the reasonable requirement of the public with respect to patent, it's a ground for issuance of compulsory license. Now, what are those circumstances when we can say that reasonable requirements are not being met? First, patent holder is not granting license on reasonable terms, and as a result of which, what happens? These are the consequences. What is happening? Patent holder is not granting license on reasonable terms, as a result of which trade or industry in India is prejudiced. Patent holder is not granting license on reasonable terms, as a result of which demand for the patented product is not met adequately. Patent holder does not grant a license on reasonable terms, as a result of which export needs are not fulfilled. The patent holder does not grant a license on reasonable terms, as a result of which the establishment or development of commercial activities in India is prejudiced. So, because the patent holder is not granting license on reasonable terms, if these consequences follow, we can say that the first ground exists. I am telling you the circumstances when you can say that reasonable requirements are not being met. I am not granting you license on reasonable terms. I have invented some technology to preserve milk at room temperature for a longer period of time, and I am not granting license to dairy industry on reasonable terms, as a result of which development of dairy industry is prejudiced. This is covered here. I have invented something which is an efficient money transaction mechanism, and I am not granting license to banking industry. I am not granting license to banks and as on reasonable terms, as a result of which development of commercial activity, banking activity in India is prejudiced. The case is covered here. So, the first situation where you can say that reasonable requirements have not been met is a situation where the patent holder is not granting license on reasonable terms, as a result of which trade or industry is prejudiced, demand for the patented product is not fulfilled, export needs are not fulfilled, and commercial activity in India is prejudiced. The second situation when you can say that reasonable requirements are not met, when the patent holder is imposing conditions which prejudice the manufacture, use or sale of non-patented material in India. You see, I am willing to give you license to sell my product, provided you undertake not to sell my competitor's product. You understand? So, this is a condition by which I am disturbing or I am prejudicing the manufacture, sale of some non-patented material in India. This is an abusive condition. If I am imposing such a condition for granting license, this would mean I am not fulfilling the reasonable requirements of public. The third situation where I can say that reasonable requirements are not being met is when I am imposing these conditions. There are three conditions which have been listed here. These can be called as anti-competitive conditions. When I am granting you the license, but at the same time I am imposing one of these three conditions. First is a condition called as condition of exclusive grant back. I am giving you my product, I am giving you the license to manufacture and sell my patented product, but I am imposing the condition that whatever improvements you do in that product, you will not claim patent on those improvements. All those improvements will exclusively come back to the patent holder, and patent holder will eventually own any IP on those improvements. This is an abusive condition. This is a non-competitive condition. This is called exclusive grant back. The second is prohibition of challenge of patent validity. I understand that if I give my patented product to you and you start manufacturing and selling, in the process you may get to know more about my product and you may realize that the patent has been wrongly granted to me. In that case, you may challenge the validity of my patent. What I am doing, at the time of granting license to you, I am imposing a condition that you will never challenge the validity of my patent. This is an abusive condition. This is an anti-competitive condition. The third is a clause, a condition which amounts to coercive package license. If you want license to manufacture my printers, you will have to also sell my cartridges. That's a condition which I am imposing. This is a coercive package license. So, if I am granting you license subject to such conditions, this is not acceptable and it amounts to a situation where I am not fulfilling the reasonable requirements of public. So, first, when I am not granting you license on reasonable terms, as a result of which trade suffers, commercial activities suffer, the export needs are not fulfilled, the demand of for the patented product is not fulfilled. Second, I am imposing conditions as a result of which the sale, manufacture of non-patented products are prejudiced. Third, I am imposing anti-competitive conditions. The fourth situation where I can say that reasonable requirements are not met is when the patent holder is not working his invention on commercial scale to an adequate extent. You give patent to me on this pen, I am not manufacturing it, I am manufacturing only 4 units and selling it at an exorbitant price. This is as bad as not fulfilling the reasonable requirements of public. So, therefore, this is the fourth situation where you can say that reasonable requirements are not met. The last one is, the last situation where you can say that reasonable requirements are not met is when the working of patented invention on commercial scale in India is prevented because of importation of patented product from some other country. The working in India is prevented, is hindered because the patented product is imported from outside. Who is importing it? Maybe the patent holder himself is importing and not manufacturing it here, or somebody authorized by him is importing, Or second, somebody who has purchased it lawfully there in that country is importing. And third, if a third party is importing without the permission of patent holder, but the patent holder has not taken any action to stop that importation. He has not filed any case of infringement. If these three conditions exist and the local working of that patent is hindered because of importation by these three, it is a case when you can say that reasonable requirements are not being met, and that is a basis for issuance of compulsory license. So the first ground, I gave you 5 circumstances where you can say that reasonable requirements have not been met. These are in the form of illustrations. These are in the form of examples. The circumstances where you can say that first ground exists. The second ground is patent holder is not making the patented product available at a reasonably affordable price, and see, there is a catch here. It is not a reasonable price, it is reasonably affordable price. There is a difference between reasonable price and reasonably affordable price. When we will talk about Protection of Plant Varieties and Farmers' Rights Act, we will see that the compulsory license chapter there talks about reasonable price. Reasonableness of price of a drug depends on the R&D investment which I have made. But affordability of drug has to do with the paying capacity of people who are going to be the users of that drug. So this is an important point, that price need not only be reasonable, it must at the same time be affordable by people who are going to be the users of that patented product. And if the patented article is not available at a reasonably affordable price, it becomes a ground for issuance of compulsory license. The third ground is working of patent in India. Patent must be worked in India. It must be worked on a commercial scale in a reasonably practicable manner. What do we mean by working of India? Working of patent in India definitely means manufacturing in India. If you do not have a manufacturing unit, you may work it by importing it into India. If you are a foreigner, you have claimed patent in India, you can license it to somebody in India who may manufacture, or it may form part of some other product that is sold in India. By these 4 methods, you can fulfill the requirement of local working of patent in India. Now, if you refer to form number 27, which is a format in which every patent holder has to furnish statement of working of patent, there are 2 columns. What is the extent of working of patent by local manufacturing? What is the extent of local working by importation? So it is not that working always means it must be manufactured in India. Working will also include working by importing the patented product into India. So the 3 grounds which I mentioned are: the reasonable requirements are not met, the patented product is not available on reasonably affordable price, and the third is the patent is not worked in India. Now, there are certain factors which the controller will have to keep in mind while granting compulsory license. What are those factors which controller will consider? I have listed some of the factors here. Controller will look into the nature of invention. Nature of invention means that, as I said, if you recall, I presented that chart in which I said that an application for compulsory license can be filed after 3 years from the date of grant, but it is possible that in a given case 3 years time is not sufficient for starting commercial working of the patent. So therefore, nature of the invention has to be looked into to take a decision whether compulsory license can be granted at this point of time or not. Second, time which has passed since the grant. You see, although we are saying that after 3 years of date of grant an application is acceptable, but in most of the cases 3 years time will go in the patent prosecution itself. So time elapsed since grant is definitely a factor which the controller has to keep in mind while deciding whether to grant compulsory license or not. Because you see, we must give importance to the interest of patent holders at the same time. It is not that patent has been granted, start manufacturing it, you fail to manufacture in first 3 months and then we are after you that compulsory license will be granted. It's not like that. We must give some reasonable time to the patent holder to start manufacturing. So, nature of invention, time elapsed since the grant, measures already taken by the patentee, 5 years have gone, manufacturing has not started. Why? Because probably the patent holder is establishing the manufacturing unit. So, therefore, what measures have been taken by the patent holder? All these factors are relevant. In addition to these factors, we must also examine the ability of the applicant. The person who has filed for or who has claimed compulsory license must have the ability to work the invention to the benefit of public. If he himself does not have the ability, no compulsory license shall be granted to him. He must have the capacity to provide the capital and take the risk required for working that invention in India. The most important is the entire process of compulsory license will start only when, first of all, the applicant proves that he has approached the owner, the patent holder, for the purposes of negotiating voluntary license. It is only when the efforts to negotiate voluntary license fails that we talk in terms of granting compulsory license. Compulsory license should be a matter of last resort. This is not something which the holder of patent is doing voluntarily. This is against the very purpose of granting patent, that is to encourage innovators to invent more. So, therefore, it must be a matter of routine, it must be a matter of last resort. The applicant must first of all establish that he tried to negotiate a voluntary license. These are some of the factors which the controller will keep in mind. But these factors may not be considered in case of extreme urgency. These factors may not be considered in case of the conditions. If you recall, I mentioned no anti-competitive practices, anti-competitive conditions. But these are exceptional situations. Otherwise, as a matter of routine, the controller will have to consider these factors while granting compulsory license. The whole idea is to balance two claims. First claim is working of invention in India. It must be worked. So, first concern is any invention must be worked in India. The second concern is the person who is already working, already developing the invention is not prejudiced in unfair manner. So, therefore, it is a balance between creator versus user. Interests of creators and interests of users have to be kept in mind in deciding what are the terms and conditions. Consideration will be given to patent holder, consideration will be given to nature of invention, the money which he has spent on creation of patent, enforcement of patent. The patent must be worked by the compulsory license, otherwise it becomes a ground for revocation of patent. The compulsory licensee must make the patented product available at an affordable price. Usually non-exclusive license shall be granted. The rights granted to compulsory licensee are not assignable. Compulsory license is granted for remaining of the terms unless, so if I grant compulsory license after elapse of 8 years from the date of grant, then for remaining 12 years compulsory license is granted unless a shorter duration justifies public interest is served. And it is primarily meant for Indian market. Section 92A clause 1 is a special provision which is based on para 6 of Doha Declaration on TRIPS Agreement and Public Health 2001. It is a provision included for granting compulsory license for manufacturing and export of patented product to any country which has insufficient or no manufacturing capacity in pharmaceutical sectors. This is something which has to do with public health. As I said, this clause, this provision is based on para 6 of Doha Declaration on TRIPS and Public Health 2001. compulsory license is granted for manufacture and export of any pharmaceutical product to any country which does not have manufacturing capability in pharmaceutical sector. Why do we do it? In order to promote, in order to address public health issues. Section 92A extends to drugs, formulations, diagnostic kits, everything. There are two conditions which have to be followed. So, compulsory license in India can be issued, can be granted to some company X to manufacture and export drugs to some country, for example, Malaysia, so as to address the public health issues in Malaysia, subject to two conditions. First, the country Malaysia should have either granted compulsory license with respect to that patented product, drug, or has allowed importation from India. So, compulsory license is granted for manufacturing and export of patented product to any country which does not have the manufacturing capacity in pharmaceutical sector so as to address public health issues, provided the country in question, in my example it is Malaysia for example, the country in question has either granted compulsory license in relation to that drug or has allowed importation of that drug from India. There have been examples where such compulsory licenses were issued and it led to reduction in price of that drug in that country, and it had addressed the public health issues in a significant way. There is an important case on the point of compulsory license. It is called Bayer Corporation versus Union of India. This is a case in which Bayer Corporation was granted patent on a drug called as sorafenib tosylate. The trade name of that drug was Nexavar. Compulsory license was requested. Patent was granted in 2008. Natco Pharma approached for compulsory license and controller granted compulsory license on all three grounds: the reasonable requirements not met, non-availability on reasonably affordable price, and third, non-working of patented product in India. Remuneration was fixed at 6% of the sale, that is Natco Pharma will pay 6% of the sale to Bayer Corporation. An appeal was filed in Intellectual Property Appellate Board where the decision of controller was upheld except that the remuneration was increased from 6% to 7%. The order was challenged before the High Court under Article 226 and the 3 points, all the 3 points, the High Court mentioned, High Court explained all the 3 grounds. The first is reasonable requirement of the public. It was argued that the drug sorafenib tosylate, the trade name was Nexavar, the drug was useful only for the patients of advanced stage liver cancer and kidney cancer. Because there are very limited number of such patients in India, we don't require a huge quantity of drugs in India. Point number 1. 2, this is not the only therapy we have. There is an alternative therapy present. So, not all the patients are going to use these drugs, Nexavar. And thus, keeping in view the demand, Bayer was producing sufficient amount and the ground that reasonable requirements of public is not met is not established. Court gave a point here which is relevant, which is important to note. Court said that reasonable requirement of public has been met or not is to be examined keeping in view the nature of the article with which we are referring to. If the product which we are referring to is a luxury product, even if you do not fulfill 100% requirement, we may still accept that reasonable requirements have been met. But in case the product in question is an essential product, as an essential article, for example, medicine, nothing less than 100% fulfillment of requirement would be sufficient. So, it depends on the nature of the article in question, and court distinguished the two. One is luxury articles, the other is essential articles, and in case of essential articles, we will accept that reasonable requirements have been fulfilled only if the reasonable requirements of 100% users are fulfilled, which in the instant case was not done. Second ground was reasonably affordable price. Court said that Act does not confer any power on the controller or any authority under the Act to decide what is reasonably affordable price. Since there is no mechanism, no formula, no power given in the Act, it has to be decided on the basis of relative prices offered by the two parties. If Bayer is offering the drug at a very high price, maybe 1,60,000 rupees for 1 month's dose, and NATCO is offering at 8,000 rupees per month's dose, then there can be only one conclusion, that the price offered by Bayer Corporation is not reasonable. Bayer Corporation argued that we have invested a lot of money in R&D, against which court asked them to present their figures, present their balance sheets in the court as evidence, which they preferred not to do. And in the absence of balance sheets and other figures, court was left with no other option but to decide this case on the basis of comparative prices offered by the two parties. In the instant case, therefore, court held that the price of Bayer Corporation was exorbitant, it is not reasonably affordable. The third point was working of patent within the territory of India. Court said that the patent holder has to satisfy the authorities under Patent Act as to why patented invention could not be manufactured in India. And if they can give justification as to why patented invention could not be manufactured, then working can be fulfilled by importation also, there is no problem. The satisfaction of the authority is particularly necessary when it is proved that the patent holder has a manufacturing facility in India. If you have a manufacturing facility, then why are you not manufacturing it in India? Why are you importing the product from outside India? That's an important question on the basis of which compulsory license will be issued. So these are the three grounds, and this is how court has responded to these points. This is how court has explained these 3 points. Reasonably affordable price is a comparative decision. Why are you not manufacturing it in India? The patent holder will have to explain it. And reasonable requirements of public means, in case of essential articles, it is fulfillment of not less than 100% of users. So that's all in compulsory license. Now we'll talk about revocation of patent. Revocation of patent is another method of challenging the patent. It again starts after the grant of patent. If you recall, while discussing about the procedure of examination, I referred to 2 kinds of oppositions, pre-grant opposition and post-grant opposition. Post-grant opposition and revocation are something which come very close to each other. We'll see how. Revocation of patent can be done on a petition by a person interested. I have already explained. Person who is working in the same field to which the invention relates. Section 2(1)(t) I have been mentioning. So person interested make a petition. This is one method. There are many methods I have listed, you can see. Patent may be revoked on a petition of any person interested. Patent may be revoked on a petition of the central government. The third is something which I have already explained. If there is an infringement proceeding going on and the defendant raises the point of or the counterclaim of revocation, during the infringement proceeding, if the defendant raises the counterclaim of revocation, in that case, I have already mentioned, the matter will be referred to High Court. That is the third point which I have mentioned. On a counterclaim in a suit of infringement, there may be a revocation decision by the High Court. There may be a revocation decision by the controller after receiving direction from the central government. And there may be a revocation decision taken directly by the central government. There are a good number of grounds provided for revocation. Section 64(1) clauses A to Q provide the grounds for revocation of patent. I have listed some of the grounds. These are quite similar to the grounds which we have discussed in section 25(1), 25(2) for pre-grant and post-grant oppositions. The first is patentability requirements are not fulfilled, novelty, inventive step, industrial applicability. Second, the person is not entitled to get patent. He is not the true inventor. Third, the patent was wrongfully obtained from the person applying for revocation. I was working in somebody's lab. I took away the notes, developed the invention, filed the application before the person who owns it could file. So it is wrongfully obtained. Patent is obtained by false representation. Patent was secretly, the invention was secretly used in India before the priority date of filing. Before you filed your application, you were already using it somewhere secretly. Next is disclosure requirement of the law has not been fulfilled. I mentioned that you have to describe your invention in an enabling manner. Enabling manner means in a manner so that a reasonably skilled person can work the invention. So disclosure requirements have not been fulfilled. Secrecy direction. I mentioned while describing examination that there may be certain inventions related to national security in relation to which central government may impose secrecy direction. And if patent has been granted in violation of secrecy direction, it's a good ground for revocation of patent. Next is foreign filing permit has not been taken. Section 39, if you recall, I said if you want to file a foreign patent, you can do it either after obtaining permission of the controller or after, first of all, filing your application in Indian Patent Office. If that has not been done, it's a ground for revocation of patent. Next is geographical location of the biological material is wrongly mentioned. And finally, last point which I have mentioned here is that the invention is nothing but part of traditional knowledge. So these are some of the grounds, not all of these. I have mentioned some important ones. These are some of the grounds which justify revocation of patent. Now let's see the various methods by which patent is revoked. Section 64, subsection 4 talks about revocation of patent for government use. Revocation for government use. Now if you see here, this is section 64, subsection 4. Here the revocation is done by High Court if the holder fails to allow the government to make use or exercise the invention for the purposes of the government. This is important to note that in section 99 we have defined government use. Government can use my invention on reasonable terms. These have to be agreed upon reasonable terms. And if I am not allowing government to use my invention on reasonable terms, then in that case, revocation of patent can be done by the High Court under section 64, subsection 4. Section 65(2) talks about revocation of patents on atomic energy. If you recall section 4, where we said that any invention which relates to atomic energy is not patentable. But if because of any reason patent has been granted, it becomes a ground for revocation of such patent. What it says, central government may direct the controller, controller will give hearing to the patent holder, and then finally the patent may be either revoked or may be allowed or may be asked to be amended. So if patent has been granted in violation of section 4, in ignorance of section 4, then under 65(2) such patents can be revoked. There is a possibility of revocation of patent in public interest, you see it is here, by central government. In 65(2), if you go back, in 65(2), central government is directing the controller. Whereas in 66, central government itself is revoking the patent. A patent which is against public interest or whose use is detrimental to public interest will be revoked by the central government. Such revocation will be published by the central government in the official gazette. What I mean by this part, use is detrimental to public interest. There may be some invention which is against public interest. There may be some patent, the use of which may be against public interest. For example, if somebody has invented a night vision binoculars and he is selling it to terrorists, the invention essentially is not against public interest. Its use is detrimental to public interest. In this situation, patent may be revoked by the central government. The next point is revocation for non-working. If you recall, I just mentioned that compulsory license may be issued after 3 years. An application for compulsory license may be filed after 3 years from the date of grant of patent. Compulsory license may be issued, but what happens if the licensee also fails to work the invention? What happens when the licensee himself also fails to work that invention? In that case, a petition can be filed by central government or any person interested for revocation on the ground of non-working of patent by the holder of compulsory license. So here, in case of atomic energy, central government is directing the controller. In case of public interest, central government is revoking on its own. In case of non-working by compulsory licensee, central government is making a petition. But the most important thing is, which I mentioned in the previous slide, on a petition by any interested person. Let's go ahead. There is a case called as Dr. Alois Wobben and another versus Yogesh Mehra and others, 2014 Supreme Court, in which law was explained and in fact streamlined by the Supreme Court. Court says there are 3 possibilities of challenging a patent. Section 25(1), which provides for pre-grant opposition by any person. Section 25(2), which provides for post-grant opposition by interested person. And section 64, which provides for revocation by interested person. Now, revocation by interested person can be done at 2 forums. One is before IPAB, which now has been abolished and the power has been given to High Court, or before the High Court in case of counterclaim. There are 4 situations now: pre-grant opposition by any person, post-grant opposition by interested person, and revocation by interested person. 1 either before IPAB, which is now High Court, and 2 in case of counterclaim before the High Court. Now, what happened in this case, Alois Wobben? There were multiple proceedings in relation to identical claims, revocation, opposition, challenged at various forums. Now, court concluded that use of word or between these two, possibilities indicates that you have to choose one of these two. If you have already filed a petition before the High Court, no such matter can be raised before the High Court as in counterclaim. Or if by virtue of raising a counterclaim the matter has been referred to the High Court, you cannot file a new petition in the High Court for the purposes of revocation. So these two became alternative, cannot be used together. The second point with the Supreme Court said that Section 64 starts with these words, subject to provisions contained in this Act, meaning thereby the 2 possibilities of post-grant challenge, one in 25(2) and the other in 64. 64 is subject to any other provision, means you can exercise an option either in 25(2) or in 64. Because both are done by interested person, an interested person cannot be allowed to challenge a patent twice. Therefore, if you have already challenged it in 25(2), you cannot challenge it in 64. And that is how multiplicity of the matter has been reduced. Now, before I stop, I will raise this question for you to answer, because it is written that the only question that remained unanswered is what will happen if a proceeding before IPAB here, this proceeding, which now becomes High Court. The question is, what will happen if a proceeding before IPAB, now High Court, is pending, and at the same time in an infringement action, the counterclaim for revocation is raised and the matter is referred to High Court. Should the court wait for the decision of IPAB, now High Court, before deciding the infringement case? Kindly think about this question. So what all we discussed here in this session, we discussed 2 very important provisions related to public interest. One is compulsory license. which became particularly important after the 2005 amendment of Indian Patent Act, by which we deleted section 5. It must be kept in mind that a situation when the ground which justifies issuance of compulsory license no more exists, there is no reason to continue with compulsory license, and thus it must be terminated. Interest of patent holder must also be given due importance. We also discussed the case of Supreme Court in relation to revocation. So this completes our discussion on patent law. We will be devoting 4 lectures on trademark and followed by 2 lectures on other form of IP. That's it on patent law. Thank you very much for joining. Thank you.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said but also in what remains unsaid. Today I'll be reading one of the shortest instances of a short story that I have ever encountered, and indeed the very charm of this particular story that I'm going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I'll be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samara. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samara and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samara to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to death. And death replied, it was not a threatening gesture. Rather, it was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samara. See you in the next episode of Literary Snippet.